Good morning and welcome to the August 6, 2025 meeting of the Texas Commission on Environmental Quality. It is 9:45. I am so sorry about being late. I have a teen boy at home that is the bane of my existence right now. Apologies, y'all. I'm joined here by my colleagues, Bobby Janeka and Katarina Gonzalez, by Mary Smith, our General Counsel, and our Public Interest Counsel, Garrett Arthur. For each item, the argument or discussion is allowed. We will inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit our registration table if you're here in person, or if you're on the webinar, email agenda@tceq.texas.gov with your name, affiliation, and the item which you'd like to comment on. We will do our absolute best to accommodate that request. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking, and please check to make sure that your line is unmuted before proceeding. Is Craig here? Can you stand up, buddy? Our beloved Craig is leaving us. He is headed to DC to do amazing and wonderful things. But I cannot tell you the impact that he has made on me personally and professionally and this commission. Very, very happy for you. Very sad for the loss of TCEQ. But you mean a lot to us. Compliance first has become my mantra. Yes, and I absolutely love it. It goes with me everywhere. You are a gentleman and a scholar, and I know you will be back, but thank you so much for everything you've done for the state. Bobby, you have anything?
I just want to echo those thoughts. Recall when you came to our agency from the Office of the Attorney General and got to meet many of your region staff through virtual meetings, as I was also virtually touring the region offices of the state. And that was a really challenging time that you joined our agency. And I'm pleased to see and have seen firsthand where your touch made its way and has discernibly transformed and improved our agency for the better. I think your competence and courage to acknowledge the priority that we need to pay to more complex investigations, even though that may result in a slightly less impressive number of total investigations that they need here. We've brought a better improvement for Texans in terms of meeting meaningful compliance across our state, and I really want to commend you on that. I hope that's an effort that continues to move forward in our agency with your good intentions moving up to federal problems. But thank you so much.
Katarina.
Well, we were a better state because of your service, and we really appreciate it. And I think we're going to be a better country because of your service. And so thank you. I don't know how we'll replace you. I was talking to the exec about that and just described you as a unicorn. So a unicorn amongst our agency. Thank you so much.
I'm sorry? Yes, come on. Mike is all yours, buddy.
Gotta be careful giving a lawyer a mic. Thank you for those kind words, Madam Chair, Commissioners, General Counsel. It has been a privilege and an honor to be at this agency, which is a world-class institution. TCQ's got a mission like none other. Every day, every single one of us at this agency is protecting human health and the environment for all Texans. And being the director of the Office of Compliance and Enforcement, we are the point of the spear for the agency's mission of every day ensuring compliance across the state of Texas. And we never remained idle. During the last half decade I was there, we did a lot of good things, and good things will continue after my absence. I'm looking forward to this and grateful for this opportunity to join EPA headquarters and take a little bit of Texas to DC and try and bring what we did in OCE to the national level. And as everyone on the commission knows, and every staff member knows, the true mettle of our agency is when things are at their worst for our fellow Texans during a disaster. Our agency is at its best. And no true test of our agency comes better than when we're in a disaster, whether it be an industrial calamity or a natural disaster from wildfires to hurricanes to floods. Everyone at this agency steps up and does their part to ensure the agency's mission is met. And every day we do protect human health and the environment for every Texan. It's been a privilege and an honor. Thank you for the kind words today. I've thoroughly enjoyed my time at this agency, and sure, I do hope to one day maybe come back. Thank you again.
And you can always change your mind.
Yes. I hope DC knows how lucky they are to have you. And with that, do you want to introduce your interim senior advisor?
Sure. Many of you know Jessie Powell. Jessie had a baby, so she's shirking her work duties to go tend to motherhood. But in the meantime, we have Aubrey. Aubrey has stepped in, has kind of a similar background to Jessie in that very heavy focus on water and practice in the environmental law division. And so they're nice enough to lend her to me for the duration of the maternity leave. And I know she's going to do a great job. She's already doing a great job. So Aubrey, do you want to say anything? Thanks.
All right, with that, let's call the first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the application by Corex Utilities for amended TPDES permit number WQ0013977701, 001. The applicant, the protestants collectively, the ED and OPIC will each have 5 minutes of oral argument time. They'll go in that order. The applicant should speak first and may reserve a portion of its time for rebuttal as the applicant bears the burden of proof in this matter. And with that, we'll begin with the applicant, the attorney for the applicant, Mr. Tuckfield.
Good morning, Madam Chairwoman and Commissioners. I'd like to reserve 2 minutes of time for rebuttal. Corex Utilities has applied for a major amendment for TPDS permit, a 5521 permit. And I might note that there's one thing I wanted to bring up as far as what you have in front of you. OPIC, in its reply to exceptions attached, rather than file a reply to exceptions, just attach its closing briefs. I objected to that, and I still object to it. And then just from a procedural standpoint, if you're going to have their closing brief, you should have our closing briefs and our reply to their closing briefs. But that's neither here nor there at this point. In any case, there's a couple key points in this case that are very important. One, the discharge is into an unnamed tributary where the receiving water is minimal aquatic life use. And that flows for a mile before it reaches the Colorado River. The primary stakeholders near and along the discharge route include LCRA, Hyatt, and McKinney-Ruff's Nature Park. None of them were protestants in this case. The summary disposition was granted on several issues in favor of the applicant, namely need and regionalization, notice, and compliance history. With respect to water quality, first and foremost, again, the first mile of the discharge is in the minimal aquatic life segment. And the other important point about water quality is that when it does reach the Colorado River, we have the Colorado Watershed Protection Rule, which this permit complies with. That rule requires a 1.0 total phosphorus, and that the permit imposed that. The protestants attempted to say that the Colorado River was already degraded. But the fact is that that segment of the Colorado River is not listed on the 303D list. And so the protestants wanted the ALJ, I guess, to change the 303D list or not follow the IPs. The IPs required that the ALJ analyze and TCQ analyze this segment in accordance with the exceptional aquatic life use designation that segment has. Protestants simply compared discharge limits with concentrations of various constituents in the Colorado River. We saw from the Save Our Springs case and the City of Dripping Springs matter that that's not how you do it. You got to look at a whole water body perspective. And with respect to nutrients, phosphorus was addressed and a phosphorus limit was imposed on the permit. With respect to nuisance odors, requirement number 5 of the other requirements of the draft permit clearly imposes the requirements that
That's 3 minutes.
okay, that requires compliance with 309.13E2. And with respect to accuracy of the application, as the ALJ pointed out, the protestants really didn't bring up any true issues with regard to that accuracy. Thank you.
Thank you very much.
Mr. Ullman for the protestants.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Eric Ullman here on behalf of the Protestant Environmental Stewardship. First, to look at the factual context here. This is a discharge from within McKinney Ruff's Nature Area that was installed by LCRA to serve a youth camp. In fact, members of environmental stewardship have children who attend that youth camp and are exposed directly to this discharge. This is taking that and expanding by a factor of 10 to serve residential areas around it, an intent never intended by this discharge. The city of Bastrop's drinking water intake is not far downstream from this discharge. The LCRA has monitored and evaluated the Colorado River here and has found that it is no longer indicated to be in compliance with the high aquatic life use for several parameters by its studies. It's looked at trends of sampling over the area, and they've shown a consistent downward trend. The applicant's own expert testified that water quality has been lowered over the past 30 years or so, and the TCQ's own designations of concerns have grown increasingly over the past 30 years. Now, I'll say a few things about the presumptions to be applied. This involves the 709 prima facie presumption. As you may know, in 2011, legislation was proposed that said the protestants bear the burden of proof. The EPA expressed concern and that was withdrawn. In 2015, we came back with this idea of a prima facie presumption applicable during the SOA proceeding that reordered the proceeding and helped to narrow the issues and allowed a summary disposition such as the applicant decided. That was not a magic wand that can be applied at this stage of the process. We're now back before you. You are to apply the applicant's burden of proof. And the burden here is influenced by the substantive law, where the TCQ rules say that every permit must include conditions to ensure protection of water quality standards. The fact that the building has a 51% chance of standing up does not ensure its integrity. We don't have to prove a water quality standard will be violated. We merely need to show that there's a reasonable potential for the violation of water quality standard here, and that is the case. Now, for regulatory context, clean water has technological standards and water quality standards. The technological standards where you have effluent limitation guidelines. It's different than the water quality standards we're looking here, such as the fact that you must not have toxic materials in toxic amounts, and you must have not have nutrients that cause excess growth of algae. Now, looking at this case, the errors in proposal for decision, the ALJ characterizes nutrients as merely based on 2 photographs. The problem here, again, is an ongoing trend showing declining water quality, consistent with that's showing those types of problems. This demonstrated there is a reasonable potential for this to cause an excess growth of algae if this discharge is permitted. We're not saying that you need to use a different characterization of the stream. We're not saying the 303D list is wrong necessarily, although we would question it as programmatic here. We're saying when you look at that and you ask, will this cause or contribute to a problem? The answer is yes. Now, as to modeling of dissolved oxygen, this assumed a stream width of 24 feet and a depth of 2 feet. Every domestic wastewater permit that comes before you uses modeling that assumes a stream as receiving stream is 24 feet wide, 2 feet deep. There's a 2-foot wide pipe immediately downstream of this. That does not in any way represent the geometry in this case. What the ALJ said is, well, this modeling is consistent with your standard practices. Your witnesses on the stand are not willing to say this modeling is accurate. It's just the way you always do it. That's not sufficient to protect water quality from dissolved oxygen, does not show existing uses are being complied with. Because the degradation over the past 30 years was not considered, it was improper to use existing conditions as the basis for tier 2 analysis. The error here is different than the error that was involved in the Save Our Springs case. That one involved Is it de minimis? No party disputed the use of existing conditions as baseline. In this case, when you look at holistic water quality, the highest water quality since 1975 was not used as baseline. This issue was one of using a proper baseline, which is an entirely different area than the ones involved in the Save Our Springs Alliance case. And then we get to toxics, where the concern was with PFAS within the discharge. There can be no real dispute that PFAS are toxic. The Texas Attorney General is suing 3M, saying that it was a Deceptive Trade Practice Act for 3M to convince regulators not to treat PFAS as toxic. That implicates your water quality standard, saying that a discharge may not be toxic to man, somewhat outdated language, but toxic in toxic amounts. It cannot be avoided, as the ALJ has done, merely by saying, well, the protestants did not demonstrate that there will be PFAS present in toxic amounts here. Again, that's not our burden. We're not the ones familiar with the nature of the discharge and with what's in the discharge.
That's time.
So for these reasons, we think the applicant has not met its burden of proof, and we would ask that you reverse the ALJ's recommendation and deny the permit. Thank you.
Thank you very much. Hear from the ED.
Good morning, Chairwoman, Commissioner, General Counsel, Public Interest Counsel. For the record, my name is Cole Malley with the Environmental Law Division, and I'm here today on behalf of the Executive Director. With me today is Abdur Rahim from the Water Quality Division. The ED respectfully requests the Commission adopt the ALJ's order with the ED's exceptions and issue the permit. The Commission referred 6 issues for the contested case hearing. The ALJ subsequently granted the applicant's motion for summary disposition on issues B, D, and F. The sole issues remain for the ALJ's consideration were issues A, C, and E. Upon review of the evidence, ALJ determined the applicant met its burden of proof for these 3 issues according to the requirements of Texas Government Code Section 2003-47 and recommended the Commission issue the permit. The ED filed 3 exceptions with the PFD, which the ALJ agreed the Commission should adopt. In summary, the ED recommends the Commission adopt the ALJ's proposed order with the exceptions and issue the permit. Thank you. We're available for questions.
Thank you very much. Any questions for the ED? OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Directors, Attorney, and staff. For the record, I am Pranjal Mehta with the Office of Public Interest Counsel. OPIC participated in the hearing, evaluated the evidence and arguments presented, and concluded that the applicant met its burden of proof for all the referred issues, except issue A, which concerns water quality. The record includes compelling data, research, expert testimony, and observations that confirm long-standing concerns about nutrient concentrations in segment number 1428 of the Colorado River. OPIC acknowledges that the draft permit includes a total phosphorus limit as required by the Colorado Watershed Protection Rules. While the rule sets a minimum phosphorus requirement, it does not prohibit a more protective limit when needed. Given the evidence showing elevated nutrient concentrations in segment 1428, OPIC believes that a more protective phosphorus limit would be necessary to protect the water quality and ecological balance of the Colorado River Basin. For this reason, OPIC respectfully disagrees with the administrative law judge's finding that the application be granted. As a result, OPIC recommends denying the application or, at a minimum, revising the draft permit to include a more protective phosphorus limit. Thank you, and I'm happy to answer any questions.
Any questions for OPIC? Nope. Mr. Tuckfield, you have 1 minute and 43 seconds remaining.
I'll make it fast. Thank you. Mr. Allman said that this permit was never intended to be expanded. There's no evidence of that. He also mentioned 2 photographs that they based their evidence on, saying that this is going to be a problem. Well, the photographs are just photographs of a river. It doesn't connect the discharge to anything that's occurring in the river itself. What you've heard is that the protestants really want to change the IPs. The IPs make it clear that baseline conditions are estimated from existing conditions as indicated by the latest edition of the Texas Water Quality Inventory or other available information. That's exactly what happened here. the TCQ's the exceptional aquatic life use designation. As far as the modeling goes, also they want you to vary from the IPs, and if we had varied from the IPs, they'd be up here saying, well, they didn't follow the IPs, so they can't, you got to deny the permit. And lastly, the PFAS contaminants of emerging concern. Mr. Allman quoted things from the Attorney General that were not in evidence. They were specifically excluded, and in fact applied to water systems, not wastewater systems. And finally, the OPIC mentioned the watershed protection rule. It doesn't say that it's a minimum. It establishes a standard, and that's the standard that applied in this case. Bottom line, commissioners, is that this permit should be issued. All the rules are followed, and so we encourage the adoption of the issuance of the permit. Thank you.
Thank you, Mr. Tuckfield. Any questions for? No? All right, thank you very much. All right, colleagues, item 1 requires us to consider the proposal for decision concerning the application for Corex Utilities Incorporated to amend its TIPD's permit to authorize increasing its discharge of treated domestic wastewater. I generally agree with how the ALJ handled the case and would adopt the proposed order with 3 corrections recommended by the recommended in the ALJ's reply to exceptions. I found that the ED's expert testimony in this case was particularly compelling. It was excellent. I was not persuaded that the protestant's testimony and evidence successfully challenged the ED's technical determinations that the draft permit is protective of water quality based on the dissolved oxygen modeling assumptions in both the Tier 1 and Tier 2 anti-degradation reviews. I believe the total phosphorus limit established in the Colorado River watersheds is appropriate, and the protestants' complaints about the ED's nutrient screening evaluation were unsupported. I believe the draft permit appropriately requires compliance with our Chapter 309 odor management plan and location requirements. And I also agree with the ALJ that the commission does not have state or federal authority to regulate contaminants of emerging concern via TIPD's permits. And I would recommend the addition of a conclusion of law to address that legal conclusion. I'm also fine with ALJ's recommended division of transcript costs at 75% to Corex and 25% to environmental stewardship. I'll stop there. Bobby?
I think I'm in agreement as well. I appreciate OPIC's acknowledgement of the concerns in regards to nutrients and impacts on the waterway. I think that is an issue that largely speaks to our agency's standards on that contaminant, rather than whether our agency would need to follow a different approach in this matter, and certainly whether the record reflects the basis to change the ALJ's opinion at all. So I'm comfortable moving forward today.
Thank you. Katarina,
I'm also in agreement. Thank you.
do I have a motion?
I would move that we adopt the administrative law judge's proposed order with the 3 changes to finding of facts number 15, 25, and 41 proposed in the executive director's exceptions and agreed to by the ALJ in her reply. Further move that we add a conclusion of law to memorialize the commission's determination on the contaminants of emerging concern issue as follows. COL 23, no federal or state law regulates CECs in TPDES permits, and therefore the issue is not a relevant and material issue for the commission to determine. I further move that we issue amended TPDES permit number WQ00139-77001 to Corex Utilities, Texas Incorporated in the form of the draft permit submitted by the executive director, and move that we adopt the executive director's response to comment.
A second. All those in favor say aye.
Aye.
Motion passes. Thank you. Thank y'all very much. We'll go to item 2, but we'll give everyone a second to shuffle.
Item number 2 is the consideration of the application by Blizzexis LLC for new TCEQ permit number WQ 0016111001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning, y'all. Before us, we have an application for a new Texas land application permit that would authorize disposal of treated domestic wastewater at a daily average flow not to exceed 12,000 gallons per day. The commission received many hearing requests and requests for reconsideration. When considering hearing requests for these types of applications, the commission considers a two-step application. First, we must determine whether a hearing requestor is an affected person. Second, we determine whether an affected person raised issues in their hearing requests that are referable to SOA. So let's talk about effectiveness. The commission received timely hearing requests from numerous individual requestors, 3 groups, and 1 governmental entity. I'll begin with my thoughts on effectiveness. To be considered an affected person, a requester must explain how they will be affected by the application in a way that is not common to a member of the general public. The hearing requester must also file timely comments in a hearing request that identifies their personal interests and the concerns that they have. Finally, the identified concerns must be within the commission's jurisdiction to address in the authorization. For governmental entities, the requester must demonstrate its statutory authority over or interest in the issues relevant to the application. For groups and associations, there are additional requirements for the commission to review. For example, to be entitled to a hearing, a group or association must identify a group member that would have standing to request a hearing in their own right. Looking at the group hearing requesters first, I agree with the ED and OPIC that the hearing request received by the Fitzhugh Neighbors, Greater Edwards Aquifer Alliance, and Save Our Springs Alliance should be granted. These groups filed timely comments and hearing requests which identified 1 or more members who I believe would have standing to request a hearing on their own right. These groups also meet the other requirements for a hearing. The interests of the group has identified are relevant to the group's mission, and their claims do not require the participation of their members to pursue. Next, looking from the request of the Hayes Trinity Groundwater Conservation District, this governmental entity demonstrated its statutory authority over groundwater protection and management in the area where the proposed irrigation sites will be located. I agree with the ED and the OPIC that the district demonstrated effectiveness. Turning to the individual requesters in this matter, I agree with ED and OPIC that we should grant the hearing requests of Susan Munns, Carrie and Vic Naporiowski, good enough? Okay. Shield Ranch, Richard and Tracy Sorensen, and Stephen Warrenchus. I also agree with OPIC that we should grant the hearing request of Kevin Fleming. Taking into the consideration of the volume of proposed land application, the issues that these individuals raised in their hearing requests, and their close proximity to the proposed facility and disposal site, I believe that they have shown that they may be personally affected by this application in a manner that is not common to the general public. I would recommend that we deny the remaining hearing requests, given that these requestors did not either file timely comments, did not raise an issue in their hearing request that was raised in a timely comment, or did not identify a personal justiciable interest in their hearing request that would sufficiently differentiate them from the general public. I will stop there, talk to my colleagues.
I arrived at the same parties.
I'm in agreement.
Let's talk about the issues. Let's move to the second part of our analysis on issues. Affected persons raised relevant and material issues regarding health, wildlife and livestock, protection of groundwater and surface water, siting, buffer zones, odor, storage capacity, effluent limits, notice, accuracy of the application, and design criteria for the subsurface drip dispersal system. These issues are within our jurisdiction to consider for a Texas land application permit, so I'd recommend that we send these issues to SOA. There is one issue regarding regionalization that I'd like to briefly address. I don't believe that this issue is relevant and material to the Texas land application permit, so I would not refer it to SOA. Texas Water Code 26.0282 expressly states that it applies to a permit to discharge waste. A Texas land application permit is not a discharge permit. Therefore, I believe that the section does not apply to this type of application. I'd also recommend denying all the requests for reconsideration because I do not believe they raise new, relevant, and material issues for the commission to consider. And finally, I'd recommend a 180-day hearing duration. Bobby?
I'm in agreement there across the board. I appreciate you pointing out the distinction on our regionalization policy and how it is not a relevant issue here because of the nuance in the legal nuance in disposal is not discharge in terms of our agency's obligations to review for regionalization. I will recognize that that may be something that the legislature takes a look at and feels strongly about, that maybe we need to be consistent across permits, but right now the law would not obligate us to that review and referral to SOA right now.
Sure, well said. Katarina?
I'm in agreement as well.
Do I have a motion?
I move that we grant the hearing request of Greater Edwards Aquifer Alliance, Fitzhugh Neighbors, Save Our Springs Alliance, Hayes Trinity Groundwater Conservation District, Kevin Fleming, Susan Munns, Carrie and Vic Naporowski, Shield Ranch, Richard and Tracy Sorensen, and Steve Warnches. That we deny the remaining hearing requests and all requests for reconsideration, that we refer the matter to SOA for a contested case hearing on the following issues: whether the draft permit will be protective of the health of requesters and their families, livestock, and wildlife, whether the draft permit is protective of water quality by preventing wastewater effluent from discharging into surface waters or adversely affecting groundwater, whether the draft permit complies with applicable siting, buffer zone requirements, including odors and effluent storage to protect against over-application and runoff of treated effluent from irrigation areas as set forth in 30 TAC chapters 309 and 222, whether the draft permit contains adequate effluent limitations and testing requirements to prevent irrigation area nutrient accumulation and leaching past the rooting zone, whether the applicant substantially complied with applicable notice requirements, whether the application is complete and accurate, and whether the application and proposed subsurface drip dispersal system comply with applicable design criteria in 30 TAC chapter 222, and specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
Second the motion.
All those in favor say aye.
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 Motion passes. Thank y'all.
Item number 3 is the consideration of the application by the City of Manor for a major amendment with renewal of TIPD's permit number WQ0014129002. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning. This is an application for the renewal and amendment of the City of Manor's domestic wastewater discharge permit. Commission received several joint hearing requests from the Wilbarger Creek Conservation Alliance and 5 individuals who are also members of the Wilbarger Creek Conservation Alliance. Given the type and volume of this discharge and given the location and distance from the facility and outfall of the individual hearing requesters, I don't believe that any of them have demonstrated that they would be affected in a manner different than the general public. So I deny all the individual hearing requests. Because these individuals were also members of the WCCA, identifies as giving it standing to pursue a contested case hearing, I would also deny the WCCA's hearing requests. With all the hearing requests denied, I would issue the permit amendment and adopt the ED's response to comment. Bobby?
I am in agreement.
I'll sign agreement.
Do I have a motion?
I move we deny all hearing requests, issue the major amendment and renewal of TPDES permit number WQ0014129002 to City of Manor as recommended by the Executive Director and adopt the Executive Director's response to comments.
A second.
All those in favor say aye.
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 Thank you. The motion passes. Give everyone a second and we will go to item 4.
Item number 4 is the consideration of Pipkin Ranch Holding LP's petition to revoke injection well permit numbers WDW 344, 345, 346, 347, 348, 349, and 350 issued to U.S. Ecology Winnie LLC. The parties have been notified that the petitioner, the respondent, the ED, and OPIC will each have 5 minutes of oral argument time and speak in that order. The petitioner may reserve a portion of its time for rebuttal as it bears burden of proof in this matter. With that, we'll begin with Mr. Tuckfield for the petitioner.
It's just your agenda day, Mr. Tuckfield.
This is my day, believe me. Thank you. I'd like to reserve 2 minutes of time for rebuttal. This is an interesting case. It's unlike anything I've ever seen, and it's been very frustrating actually as we've gone through it. There are 6 salient facts that are really important for you to understand. By interim order dated February 27th, 2024, the commission found that the Pipkins had standing and were granted standing for a contested case hearing. The permit application involved a renewal. And according to the renewal rule, merely applying allows them to continue to operate under that permit until the contested case is resolved. The commission referred the question, and this is where it becomes different than almost anything else that you've seen, whether any existing rights, including but not limited to mineral rights, will be impaired by U.S. Ecology's injection of industrial municipal non-hazardous waste in accordance with the Texas Water Code. So basically the Pipkins said, look, they're using our land, our pore space, and they continue to do it. And this renewal, we want a contested case hearing. You granted the contested case hearing on that specific issue. And instead of actually sending or doing what it takes to get this sent to SOA, U.S. Ecology just sat on it. Now they claim there were settlement discussions. Even if there were settlement discussions, and we can go back and forth all day on that, there weren't. There were a couple discussions. Are we going to settle? I said, no, I don't think anything's going to really happen. It's really been settlement and be driven by something else. Even if there were settlement discussions, that doesn't matter. Every case I've been involved in the last 35 years, you go to SOA. If both parties want to get an abatement, they get an abatement, and they go from there. Or you settle during the contested case hearing, or you have mediation. There's lots of things that can happen. But what happened here is U.S. Ecology just decided unilaterally, we're not going to take this. We'll just continue to use this renewal. We'll invoke the renewal rule, continue to do what we're doing to the Pipkins. And frankly, if we hadn't filed this petition to revoke, I doubt it would have been referred to SOA at all. It got referred to SOA as soon as we filed the petition to revoke. So the question then becomes, did they violate the law? The permittee was required pursuant to section 80.118 D1 to forward the application within 10 days. Now I get that not everybody does it within 10 days, but this went 400 plus days just sitting there, and they're operating their renewal permit. We already talked about settlement discussions a little bit. The commission has the authority to revoke the permit, the application for renewal, and the amendment or the interim order, and tell U.S. Ecology you got to reapply because you just sat on it. You're obviously not interested. Reapply. You can do any one of these things.
That's 3 minutes.
And you have that authority under 305.66A, which allows a permit or order of the commission to be revoked for good cause at any time. Thank you.
Thank you.
The attorney for the respondent next.
Hello, good morning, Commissioners and General Counsel. My name is Maddie Nader. I'm the attorney for U.S. Ecology. First, I'd like to just very briefly address Mr. Tuckfield's statements regarding the purported misrepresentation. We did file some supplemental briefing on Friday, which I have printed copies available if y'all haven't had the chance to get it. But that supplemental filing simply provided an affidavit of Duncan Norton, my co-counsel, as well as a sworn declaration of David Jones, the counsel for the litigation matter. There is a simultaneous litigation in the civil courts occurring for this to indicate the conversations that we've had regarding settlement that have been ongoing intermittently during this process. We were ultimately awaiting the trading of expert reports in the litigation matter, and that finally occurred ultimately last week. So we were prepared to recommence at that point. However, we weren't informed that they were ready to continue with a contested case hearing until the filing, well, until we received notice of the filing of this petition. So any call at any point would have prompted us to move forward if we understood that settlements were not continuing to undergo. However, I don't believe that that is the relevant part of our argument or of this matter. What is relevant is that the petition to provoke fails to provide any of the statutory or rule-based requirements for revoking a permit of an ongoing business that has been operating for over 25 years to warrant this extreme situation of revocation of a permit. I just would point out that, Mr. Tuckfield references 30 TAC 305.66, which allows the commission to revoke a permit for good cause. However, as actually briefed in our initial response, they failed to review and reference 305.66G, which mandates that before denying or suspending or revoking a permit under this section, even if it is for good cause, the commissioner must find one of two things. That is, one, that a violation or violations are significant and that the permit holder or applicant has not made a substantial attempts to correct the violation, or two, that the permit holder or applicant is indebted to the state for fees, penalties, or taxes under the Health and Safety Code for commission rules. Neither of those requirements have occurred, and in fact, they haven't even been alleged. Even if the commission found good cause, this subsection G still applies, and neither of these have been found. We corrected this application oversight of failing to file this as soon as we received notice of this petition to revoke, and this has been set for contested case hearing, I believe, on September 23rd. So we ask that you simply deny the Pipkins petition to revoke this application for a lack of legal basis and allow this matter to proceed to a contested case hearing, which, like I said, has already been set for a preliminary hearing. I'm available for any questions, as well as my co-counsel, Duncan Norton, who is the author of the affidavit that we submitted on Friday. He is available online on the webinar for questions as well.
Thank you, Ms. Nira. Any questions for?
I have a question. I don't know if it's most appropriate for this responder right now or whether we should direct it to the executive director staff. I'm curious if someone could describe briefly what the major amendment component of this matter would seek to obtain for the company.
Yeah, so our application was actually submitted for just a basic renewal, but because of some geological subsurface changes, the technical staff required some changes. I think I would direct that to the ED and the technical and the TCQ technical staff to kind of explain those, because they are very technical. But we aren't requesting or amending it to add waste, and we're not changing the type of waste. So it's purely like a geological system that I'm sure that the TCQ team could explain in more detail.
Katarina, anything? Nope. Right, thank you very much.
Thank you.
You're from the ED?
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Don Redmond, an attorney with the Environmental Law Division With me today is Brian Smith, manager of the Underground Injection Control Permit section. The executive director respectfully recommends the commission deny the petition to revoke injection well permits WDW 344 through 350 issued to U.S. Ecology Winnie. The petition does not establish the requisite grounds for revoking a permit under applicable rules and statutes. To address Commissioner Janeka's question, there is an amendment application to increase the injection zone for the injection well permits that's handled with the application to renew the same permits. Thank you. We're available for questions.
Thank you, Don. Any questions for ED? Nope. For OPIC?
Hi, excuse me. Yes, good morning, Chairwoman, Commissioners, General Counsel, and the Executive Directors, Attorneys, and Staff. I'm Sheldon Wayne with the Office of Public Interest Counsel. After review, OPIC finds that the permit revocation is not warranted under the circumstances alleged by petitioner. First, OPIC must observe that the rule under which the petition has been brought appears to be inapplicable. Among other things, Section 305.66F allows the Commission to revoke an original or renewal permit. However, the subsection cited by petitioner, F5, specifically applies only to a hazardous waste management facility. While the definition of hazardous waste management facility does include injection wells, the U.S. Ecology facility is not a hazardous waste facility. The active permits held by U.S. Ecology and the renewal applications are for non-hazardous industrial and municipal wastes and do not seek to authorize the injection of any hazardous waste. Therefore, OPIC is unable to find that the petition states valid grounds upon which relief may be granted. Even if we assume for the sake of argument that Section 305.66F5 does apply to the U.S. Ecology's facility, OPIC cannot agree with petitioner that applicants' delay here in providing copies of its application to the chief clerk should result in revocation of its existing permits. Applicant has arguably violated Commission Rule 80.118D1, which requires an applicant to provide copies of its application to the chief clerk no later than 10 days after the commission order is mailed. The harm that petitioner claims to have suffered by this violation is the delay in having its claims promptly heard by SOA in a contested case hearing. However, OPIC is unpersuaded that the applicant's delay here demonstrates that U.S. Ecology meets the standard for revocation, which is that the applicant will be unable to ensure that the management of the hazardous waste management facility conforms or will conform to this title and the rules of the commission. U.S. Ecology has been operating the facility for approximately 25 years and has a compliance history rating of 0.0, which qualifies as high. Furthermore, while the significance of the settlement negotiations has been disputed by petitioner, OPIC understands that U.S. Ecology was in communication with TCEQ's alternative dispute resolution program during this time, and it is a common practice to allow reasonable postponement of the SOA docketing process to allow for settlement discussions at the commission level. Additionally, the rule is silent as to the effect of noncompliance with the 10-day deadline that it imposes. Moreover, commission rules require that before revoking a permit, the commission must find that 1, violations are significant and that the permit holder has not made a substantial attempt to correct the violations, or 2, that the permit holder is indebted to the state for fees, payment of penalties, or taxes. The petition does not allege that either of these conditions apply here, and OPIC cannot agree with petitioner that the violation of Section 80.118D1 is significant enough to warrant permit revocation. Additionally, U.S. Ecology has made a substantial attempt to correct the violation. Applicant states in its response brief that on April 28, 2025, it filed the required application materials with TCEQ's chief clerk. At this time, the SOA docketing process has been completed and a preliminary hearing has been set for September 23, 2025. Finally, although petitioner based its petition on violations of 305.66F5, for the first time in his reply brief, petitioner cites to 305.66A, which allows revocation of a permit for good cause and includes an illustrative list of conditions that demonstrate good cause. For instance, subsection 10 of this rule allows revocation for such other cause sufficient to warrant termination or suspension of the authorization. OPIC does not find that the circumstances present here, noncompliance with procedural or administrative requirements, justify revocation. Instead, the revocation rules cited by petitioner appear to be more intended to apply to abandoned facilities, facilities with substantive environmental violations, and facilities whose operation has been shown to endanger human health or the environment. In conclusion, OPIC finds that the rule originally cited by petitioner as the basis for the incident petition is inapplicable to the permits at issue here. Further, if the commission determines it may consider revocation under 305.66A, OPIC does not find that the petition's allegations, even when taken as true, are sufficient to warrant revocation of US Ecology's permits. As such, OPIC respectfully recommends that the commission deny this petition to revoke. Thank you, and I'm available for any questions.
Thank you, Sheldon. Any questions? Excuse me. Very thorough. Appreciate it. You have 1 minute and 46 seconds left for your rebuttal, Mr. Tuckfield.
By just failing, willingly failing. I'm sorry. Did you say I had to start over again? You heard me, right? Okay. The fact is that this, this and the supplemental filing is just irrelevant as far as what the applicant submitted, because the supplemental filing actually confirms that there was very little settlement discussions. And moreover, the settlement discussions mean nothing here. What they should have done, what the rule requires it, not just procedurally, but because this case involves a question of property rights. And they're just trampling over the property rights of the Pipkins, and they just were happy to do it as long as they got away with it. And so we're very upset about this. This is a substantial violation. It may seem insubstantial, but it hurt private property ownership of people in Texas. And you should do something about it. Thank you.
Any questions for Mr. Tuckfield? Nope. All right. Well, I'd like to start off by saying I take the petitioner's allegations of delay very seriously. However, given that the U.S. Ecology quickly filed its application with the chief clerk's office once petitioner threatened to file a petition to revoke, and that the application was referred to and is currently pending at SOA, I don't believe Pipkin Ranch Land Holdings has shown good cause to revoke U.S. Ecology's 7 UIC permits or the commission's interim order. If Pipkin Ranch wished to move forward with this matter along at SOA, it could have reached out to the applicant or to the chief clerk's office sooner to inquire about the delay in referring this case to SOA. Therefore, I deny the Pipkin Ranch petition to revoke U.S. Ecology's UIC permits and the request to revoke the application and the commission's interim order referring this matter for a contested case hearing. Pause here. Bobby?
I'm in agreement, Chairwoman. I think that describes it well. It appears to me that the part of the disconnect here was largely our agency relies on the simple fact that when referrals go to SOA, entities seeking some regulatory permission or approval have a strong clock ticking, a strong incentive, a strong desire to move things quickly. And I think I understand how this did qualify as a major amendment, but doesn't represent something meaningful that the applicant needs or this regulated entity needs. And so this has resulted in the highest relief that would be appropriate for this type of an ask. It's now docketed, it's moving at SOA. So I appreciate Mr. Tuckfield's expressions of earnestness and urgency here, and I'm going to take that in a good manner as well. I think this is it would be an inappropriate use of our agency's authority to act so finally responding to what largely is a procedural requirement, and one where our rules don't put any clear consequences in there. I think reflects the fact that it is there and to keep the process moving, and the process is moving now.
Thank you, Commissioner.
Yeah, I think that was well said. I acknowledge that this is difficult, but see that I think the law requires us to act in that particular way. So.
Right, do I have a motion?
I'll make a motion. I have one other point I wanted to respond to, and I debated whether to ask her to come back to the stand and clarify or elaborate on her answer, but I heard from the witness for U.S. Ecology that they described the decision not to file or the delay in filing to be an oversight. I'm a little troubled by it being described as an oversight. I was under the impression that there's some deliberation going in managing overlapping resources where technical, legal, administrative staff are all being allocated for a civil matter outside of our agency's purview or in the administrative process through SOA under our agency purview. I appreciate how we try to give deference and accommodate the different parties' engagement and involvement in those parties. So I'm very curious to know the thinking about it. I didn't want to drill down into that here, but I do take seriously the allegation of a delay, and the perception of delay from any of the parties is one of the quickest ways to erode that trust across where we try to work these difficult decisions. So I appreciate, sorry for going on a little bit extra, and I have a motion. I said I would have a motion. I move that we deny Pipkin Ranch Holdings LP's petition to revoke U.S. Ecology Winnie LLC's TCQ permit numbers WDW 344 through WDW 350. Further move that we deny Pipkin Ranch Holdings LP's request to revoke the renewal of U.S. Ecology Winnie LLC's TCQ permit number WDW 344 through WDW 350, and that we deny Pipkin Ranch Holdings LP's request to revoke the Commission's interim order in TCQ docket number 2023-1590-WDW.
A second. All those in favor say aye.
Aye.
Aye. The motion passes. Thank you. Thank y'all very much. Thanks, Don. Now let's go to item 5 once everyone shuffles.
Item number 5 is the consideration for adoption of a resolution reauthorizing the ED to enter into and manage contracts, including grant agreements, and to delegate authority to staff. The executive director's staff is here to present this item.
Good morning.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Angela Burnett, staff attorney with the General Law Division representing the Executive Director. This item relates to the administration of contracts and grants on the behalf of the Commission. Chapter 5 of the Texas Water Code authorizes the Executive Director to manage the administrative affairs of the Commission under the general supervision and direction of the Commission. Specifically, Section 5.229 authorizes the Executive Director, with the consent of the Commission, to negotiate and enter contracts and other agreements with various entities, including the United States and its agencies, states and Texas political subdivisions of the state, or with any other entity to carry out the Commission's powers, duties, and responsibilities. Section 5.124 of the Water Code authorizes the Executive Director, with the consent of the Commission, to award grants for any resource conservation or environmental protection purpose. Section 2261.254 of the Texas Government Code permits the Commission to authorize the Executive Director to approve and sign contracts for the purchase of goods and services that are valued over $1 million. This section also allows the Deputy Executive Director to sign contracts over $1 million. Finally, for efficiency in making payments, the Texas Comptroller of Public Accounts allows the governing body of a state agency to authorize the agency's Executive Director to designate one or more individuals to approve the agency's payment documents pursuant to 34 Texas Administrative Code, Section 5.61H1. The resolution would allow the Executive Director to delegate all such contract authority to the Deputy Executive Director and other agency staff. The Commission retains oversight of the contracts and grants through 2 existing practices. First, selected contract briefings on a quarterly and as-needed basis from the Executive Director and staff, including reporting by the Financial Administration Division for contracts of $5 million or more with risks related to the solicitation. GL debriefings include contracts that are expected to exceed $3 million or for mission critical work or have commission or public interest such as significant risk for injuries, property damage, or failure of performance, significant impacts on agency resources, or significant financial, legal, or public policy concerns. In addition, there are quarterly agenda items to consider material changes to contracts pursuant to Section 2155.088 of the Texas Government Code. The proposed resolution delegates authority to the executive director for these purposes until revoked or altered by the commission, continuing authority previously granted in the current resolution. The ED staff plans to continue the practice of updating this delegation following regular legislative sessions and as needed. Eliminating the expiration date of the resolution will help ensure continuity in the contract approval process and operations of the agency. The executive director respectfully requests your approval of the proposed resolution, and I'm available to answer any questions that you have.
Thank you, Angela. Any questions? Garrett?
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC has reviewed this item and agrees that a new resolution is needed to replace the expiring resolution. We support adoption of the proposed resolution to provide the Commission's consent and delegation of authority for the ED to enter and manage contracts and grants and process invoices for payment.
Thanks, Garrett. Has anyone signed up on this item?
We don't have anyone signed in on this one.
Thanks, Mary. Well, colleagues, I'm generally comfortable with renewing the delegation of contract authority as set up in the proposed resolution, except that I would prefer to continue renewing the resolution every 2 years. My rationale, it's not our money, it's taxpayer money, and we are appointed as fiduciaries for the state of Texas, and we need to have eyes on it as a commission. Renewing every 2 years allows a natural space for the commission to ensure that no laws affecting the delegation were passed during the previous legislative session, and gives the commission the opportunity to reflect on the processes in place to oversee agency contracting. So I'd adopt the resolution, but add a provision stating that it will expire on August 31st, 2027. Bobby?
I appreciate your thoughts on it. I agree entirely on your position on it and shared your concerns about us departing from the practice of continuing to come back to the agenda every 2 years to renew it. I take comfort in the good review of all the legislative implementation, everything that happens and is reported to us routinely. And so I was prepared today to express my discomfort generally about us removing that check-in with the confidence that I know that ED staff would do it, and I appreciate them indicating that it is a lift to continue to come back before agenda. We have tight agendas, frankly, where we will have matters that we're trying fiercely to handle as expeditiously as we can, but every one of the issues and decisions that come before our agency brings with it the potential for tremendous complexity. And so I appreciate ED signaling to us that they could confidently continue to report on that elsewhere in our agency processes. I'm prepared to go with your motion today, as you described.
Thank you, Bobby. And this is no reflection on the ED staff. ED staff are the best and the brightest in the state of Texas. This is more that we are fiduciaries. We have to have eyes on this. Nothing hurts a agency more than a bad contract, and we don't want that at TCEQ.
I'm comfortable with her.
Thank you. All right, I move we adopt the contract delegation resolution as recommended by the executive director, but add the expiration date of August 31st, 2027.
I second.
All those in favor say aye.
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 Thank you. Motion passes. Go to item 6, please.
Item number 6 is the consideration for adoption of the renewal with amendment of the TCEQ Evaporation Pond General Permit number WQG1000000. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I am Shannon Gibson with the Water Quality Division. With me today is Fernando Salazar Martinez with the Environmental Law Division. Staff request adoption.
Shannon, will you speak up a little bit? I'm sorry. I'm hard of hearing, so.
I'm a soft speaker.
Okay.
Staff request adoption of a renewal with amendments of TCEQ General Permit Number WQG 10000, authorizing wastewater generated by industrial or water treatment processes to be disposed of by evaporation from surface impoundments adjacent to water in the state. The proposed permit will replace the current general permit when it expires on September 15th, 2025. Public notice of the draft permit was published in the Texas Register and Houston Chronicle newspaper on February 7th, 2025. A hybrid virtual and in-person public meeting was held at TCEQ on March 10th, 2025, and the public comment period ended on the same day. No comments were received during the public comment period. Staff recommends adoption of this general permit. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Any questions for Shannon? Edie? Is anyone signed up on this item?
No one signed in.
Garrett?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez. I'm with the Office of Public Interest Counsel for the record. We've reviewed the renewal with amendment of the TCEQ evaporation pond general permit, and we support adoption. The renewal permit contains appropriate and protective provisions, and public participation has been adequately solicited, but no concerns were ultimately raised by either the permitted entities or the public. Further, the general permit is not subject to EPA review, and we too raise no objections. Thank you. I'm available for any questions.
Thank you, Eli. Any questions about this? Eli? I have a question about the baby. How's the baby doing?
The baby, thankfully, is mostly sleeping through the night. About 5 a.m. she wakes up, and that's my alarm clock nowadays. But that's a great trade-off as compared to the 1.5 hours when she was 3 weeks early and was very hungry and very small. So going well. Thank you for asking.
Eli, what's her name?
Gianna Elise.
Oh my gosh, it's beautiful. Wow.
Thank you.
I'm glad you're sleeping a little bit more. All right, I'd like to thank staff for the work on this item. The current permit will be expiring next month. This renewal with amendment makes some clarifying and conforming changes that are appropriate and should improve and clarify the permit, and I'm ready to move forward. Bobby?
I am too. The only question I had about this permitting area, the space that we had, was answered by our agency's guidance documents that we provide on our website. And my question is, as the rate of evaporation and the rate of rainfall in different areas of our state might change, which this permit is only available to those entities and areas of the state where evaporation exceeds rainfall, how and where is that acknowledged in this permit? And that's your old shop that will be responsible for handling that thorny question. We direct applicants to look to the Water Development Board, I believe. Great. Glad to see head nods.
They have
Yes,
good
that is
stuff
correct.
on their website.
Thank you.
All right, Pat, are
Shannon.
you- Nope. Do I have a motion?
I move that we adopt the renewal and amendments to TCQ General Permit Number WQG 1000000 as recommended by the Executive Director, and that we issue the Executive Director's proposed resolution.
I second.
All those in favor say aye.
Aye.
Aye. The motion passes. Thank you. Go to items 7 through 9.
Okay, we'll begin first with item 7, and that is the consideration for adoption of 5 total maximum daily loads for indicator bacteria in the Mustang, Persimmon, and New Bayous watershed of the Bays and Estuary Basin. And the Executive Director's staff is here to present this item.
Morning.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me virtually today are Wyatt Eason with the Total Maximum Daily Load Program and Marichello Zertucci with the Environmental Law Division. Today, the Executive Director is requesting final adoption of 5 total maximum daily loads for indicator bacteria in the Mustang, Persimmon, and New Bayous watershed. The TMDLs cover 5 assessment units in 3 water bodies within Brazoria and Fort Bend counties. A stakeholder group was formed with balanced representation of all interested parties who were tasked with providing input on the TMDL document. The active public participation effort and balanced stakeholder group was coordinated by TCEQ and the Houston-Galveston Area Council. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop the document to improve water quality in their community. The Executive Director respectfully requests the adoption of the total maximum daily loads, and permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we're available to answer any questions that you have.
Thank you, Nicole. Any questions for the ED? Nope. Has anyone signed up on this item? Nope. Garrett?
OPIC has reviewed this item and notes the lengthy stakeholder and public outreach efforts that started in 2020. To date, no EPA comments and no public comments have been received. We support adoption of these 5 TMDLs.
Excellent. Thank you very much. Again, I'd like to thank staff for all their hard work that went into developing these TMDLs. I'd also like to thank the stakeholders that participated in the development of this document, and I'm prepared to move forward. Bobby?
Likewise.
Katarina? All right. Do I have a motion?
I move that we adopt 1 total maximum daily load for indicator bacteria in Ponish Park. Nope, I apologize. I move that we adopt 5 total maximum daily loads for indicator bacteria in the Mustang, Persimmon, and New Bayous watershed of the Bays and Estuaries Basin in Brazoria and Fort Bend counties as recommended by the Executive Director.
Do I have a second? Second. All those in favor say aye.
Aye.
Aye. Motion passes. Thank you.
Okay. Items 8 through 9 are the consideration for adoption of 1 total maximum daily load for indicator bacteria in Ponish Park of the Bays and Estuaries Basin in Nueces County, and consideration for approval of the implementation plan for 7 total maximum daily loads for indicator bacteria in the Corpus Christi region of the Bays and Estuary Basin. And the Executive Director staff is here to present these items.
Hello again, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me virtually today are Wyatt Eason with the Total Maximum Daily Load Program and Marichello Zertucci with the Environmental Law Division. Today, the Executive Director is requesting final approval of 1 implementation plan and final adoption of 1 TMDL document. Item number 8 is 1 total maximum daily load for indicator bacteria in Ponish Park. The Ponish Park TMDL covers 1 assessment unit and 1 water body within Nueces County. And item number 9 is for the implementation plan for 7 total maximum daily loads for indicator bacteria in the Corpus Christi region. The activities within this implementation plan target 7 assessment units and 4 water bodies within Nueces County. Stakeholder groups were formed with balanced representation of all interested parties for each project watershed, which were tasked with providing input on the TMDL document and the implementation plan. The active public participation effort and balanced stakeholder groups were coordinated by TCEQ and Texas A&M University at Corpus Christi. The success of these projects is due to the collaborative effort of the individuals and organizations who put in the time to develop the documents and improve water quality in their communities. The Executive Director respectfully requests approval of the implementation plan and adoption of the total maximum daily load. Permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions.
Thanks, Nicole. Any questions for the ED? Has anyone signed up on this item?
No one signed in on these.
Garrett?
Regarding the Ponish Park TMDL, OPIC notes the lengthy and robust public participation process, which started in 2022 and includes Texas A&M Corpus Christi. We further note that EPA's comments have been addressed, and we appreciate the support from the Parks and Recreation Advisory Committee. Regarding the Corpus Christi Regional I-Plan, OPIC notes the appreciative public comments and would like to emphasize the broad coalition of support, including stakeholders such as the Sierra Club Coastal Bend Group, the Corpus Christi Taxpayers Association, and the United Corpus Christi Chamber of Commerce. We support adoption and approval of items 8 and 9.
Thank you, Garrett. Any questions for OPIC? Nope. Well, like the previous item, I'm thankful for all the time and good work that's gone into developing the TMDLs and the I plan for these items, both our dedicated staff and the stakeholders. Texas A&M Corpus Christi, are those the Sea Aggies? Is that Galveston? Does anyone know? Galveston, okay. They're the Islanders. They're the Islanders, sorry. Thank you to the Islanders at Texas A&M, whose stakeholders who participated in the process, and I'm ready to adopt. Bobby?
Likewise.
Do I have a motion?
I move that we adopt one total maximum daily load for indicator bacteria in Honish Park of the Bays and Estuary Basin in Nueces County as recommended by the Executive Director, and approve the implementation plan for 7 total maximum daily loads for indicator bacteria in the Corpus Christi region of the Bays and Estuary Basin in Nueces County as recommended by the Executive Director.
Second motion.
All those in favor say aye.
Aye.
Motion passes. Thank you. Thank you, Nicole. Let's get to the enforcement docket.
Okay, that takes us to the enforcement docket. That's items 10 through 35. And I'll start off noting that items 18, 31, and 35 were previously remanded to the ED. And the Executive Director staff is here to present the remaining matters.
Good morning.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 10 through 17, 19 through 30, and 32 through 34. The total assessed administrative penalties are $386,488, with $41,723 deferred, $76,396 applied for supplemental environmental projects, and $268,369 to the general revenue. In regards to the items that were remanded, for item 18, the respondent, City of Stephenville, has elected to participate in the supplemental environmental project and will need additional time for this process. For item 31, Lonnie Brown, the respondent has passed away. For item 35, Complex Ready Mix, in preparation for agenda, we identified the need for further discussion and potential modifications towards resolution of this matter. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you very much. Any questions for the ED? Nope. Has anyone signed up on any of these items, Mary?
On item 11, we have an individual who has indicated that they don't wish to address the commission, but they're available for questions.
Do we have any questions for the gentleman on item 11, commissioners? Yep. All right, OPIC?
OPIC has reviewed each of these enforcement items, and except for remanded items 18, 31, and 35, we support adoption of all the orders presented by ED staff.
I'd like to thank staff for their work to bring these items before us today. And I actually would really like to thank y'all for explaining why certain items were remanded. I think that's helpful to know. I've reviewed these items that are before us and I'm ready to move forward.
Likewise.
Do I have a motion?
I move that we adopt items 10 through 17, 19 through 30, and 32 through 34 as recommended today by the Executive Director.
Second. All those in favor say aye.
Aye.
Aye. The motion passes. Thank you.
Okay, that brings us to our public comment session. The commission will receive comments from the public on any matters within the jurisdiction of the TCQ in accordance with Texas Water Code Section 5.112, except for pending permit matters or other contested cases like enforcement matters, which are subject to the ex parte prohibition found in the Texas Government Code Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Please note that the commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response and recitation of existing policy. And with that, the first person we have signed in is Errol Summerlin, and he is virtual.
Errol, are you there?
Good morning, commissioners. Can you hear me?
We can.
Thank you. My name is Errol Summerlin. I'm co-founder of CAPE, and I now live in Salisbury, Maryland. I'd like to speak today about the 1 mile rule and cumulative impacts of permitting large industrial facilities near population centers. So what's so magical about the 1 mile rule? That's just a 20-minute walk. Along Refinery Row in Corpus Christi, you will find multiple industrial sources of emissions within 1 mile. We know you use this measuring stick, but why? Distance may be a valid criteria for evaluating health impacts, but it should not be used as a starting point to obtain affected party status. And the fundamental problem with your use of any distance measurement is that it only measures the distance from the industry being permitted. It does not take into account the other industry's emissions and the cumulative impact of the combined emissions. Let's look at distance for a moment. In April 2021, doctors and researchers at the Texas Health Institute found residents in Nueces County Census Tract 5 have a life expectancy of just 70 years, whereas in Census Tract 54, a mere 10 miles south, folks have a life expectancy of 85 years. Let that sink in. Life expectancy in Census Tract 5 is 15 years less than the south side of Corpus Christi. Census Tract 5 is at the doorstep of Refinery Row. But 11 years earlier, in 2010, doctors at Driscoll Children's Hospital in Corpus Christi evaluated the association between distance of a residence to sources of petrochemical air pollution and the prevalence of respiratory disease to determine the distance at which a residence near sources of this pollution becomes a risk for respiratory disease. Their findings: the proximity of residents to petrochemical plants is positively associated with prevalence of respiratory disease and asthma in children. The association is most significant within 15 to 20 miles. And as healthcare providers, they state, we must promote increased respiratory health surveillance of children who reside close to petrochemical plants and advocate that petrochemical plants should not be built within 20 miles of residential areas. Now, I know the impacts of air pollution is far-reaching. It is not confined to a 1 mile radius from a single facility. Let's find a way to engage the local medical community in the permitting process. They can better inform us on the cumulative impacts of these emissions and the health consequences of adding more. Let that be our measuring stick. Thank you very much for your time today.
Thank you, Errol. Much to think about. Anyone else signed up? Do you have anything, Bobby?
We have Mr. Jason Hale, also virtual.
Mr. Hale, are you there? Jason Hale?
He's not online.
Is there anyone else signed up?
No.
All right.
The next items are for executive session or closed session, and the commission will not be meeting in closed session today.
With that, this agenda of the Texas Commission on Environmental Quality stands adjourned. The time is 11:09.